Good afternoon, Madam Deputy Registrar. Kindly call the matter.
Good afternoon, Judge. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, delivery of reserved judgment in CCJ appeal, BBCV number 1 of 2025 between Massy Stores, Barbados Limited, and Merton Forde. The members of the delivery panel are Madam Justice Raj Notley, presiding judge.
Good afternoon to everyone.
Mr. Justice Barrow.
Good afternoon.
Mr. Justice Jamada.
Good afternoon to everybody.
Madam Justice Ononiwu.
Good afternoon, everyone.
And Mr. Justice Ibu Osuji.
Good afternoon, all.
May we have the appearances, please? Thank you.
May it please the court, as before, I am Michael Koyman of Dentons Delaney, attorneys at law for the appellant in this matter.
Thank you very much, Mr. Koyman.
And if it pleases your honours, good afternoon. Tariq Khan, appearing in association with my colleague, Ms. Michelle Forde, and the respondent, Mr. Merton Forde, is here present and will remain off camera. Thank you, your honours.
Thank you very much, Mr. Khan. Counsel, I thank you all for your assistance in this matter throughout this case. I will read a summary of the court's judgment. Kindly note that this summary is not intended to be a substitute for the judgment of the court or to be used in any later consideration of the court's judgment. You will observe that the court has a judgment. 4 of us are in the majority in the matter, and 1 judge has dissented. Thank you. And I will read the summary now. Massy Stores, Barbados Limited, the appellant, appealed to the Caribbean Court of Justice, the CCJ, against the decision of the Court of Appeal, which upheld a magistrate's finding that Mr. Merton Forde, the respondent, was wrongfully dismissed from his employment with the company. Mr. Forde started working with the company in 1977, and he was summarily dismissed in December 2021 for the unauthorized taking of the company's property, that is to say, condemned rice. The letter of dismissal stated that Mr. Forde was dismissed on 2 grounds. 1, substandard work performance, and 2, failure to comply with and enforce the company's rules, regulations, policies, and procedures. At the time of the incident, Mr. Forde had served the Massy Stores and his predecessor, Supercenter, for 35 years. He worked as the backdoor receiving supervisor with responsibility to ensure that goods were not moved through the back door, contrary to the company's policy. A sign which prohibited this unauthorized removal was posted on the door in the back door area and warned of disciplinary action for its violation. Contrary to the policy on the day in question, Mr. Forde sent a subordinate to place in Mr. Forde's car a bag containing condemned rice taken from the employer's store. The employer placed a camera or cameras which captured the occurrence. A hearing was conducted at which Mr. Forde denied the occurrence. He also claimed to have paid for what was taken. At a subsequent hearing, he was summarily dismissed without notice or salary in lieu of notice. The proceedings in the magistrate's court revealed that Mr. Forde was familiar with the appellant's policies but did not always follow them. Further, Mr. Forde had breached the policies in the past and had been warned but not disciplined. His Worship, Mr. Wayne Clark, the magistrate, determined that the summary dismissal of Mr. Forde by the appellant had been disproportionate and thus wrongful. The magistrate recognized that at common law, summary dismissal allows for the dismissal of an employee without notice in instances where the employee has committed a repudiatory breach of an essential term of the employment contract. He considered, however, that this form of dismissal was reserved for the most serious offences and was not warranted in this instance. The majority of the Court of Appeal, Justices of Appeal Cumberbatch and Reefer, with Justice of Appeal Bell dissenting, upheld the magistrate's use of reasonableness as a metric in evaluating Mr. Forde's conduct. The majority endorsed the use of a contextual approach to summary dismissal, which approach recognizes that while an employee's conduct may warrant dismissal, it did not automatically justify summary dismissal if other relevant considerations were present. The majority of the court expressed the view that this was consistent with the humanizing patina approach. Justice Rajnath, who authored the majority opinion, with which Justices Jamada Ononuwu and Ebo Osuji agreed, reviewed several Barbadian authorities that confirmed the use of the contextual approach to reviewing the summary dismissal of an employee. In particular, the majority of this court noted that in the case of Ramsey against St. James Beach Hotels Services Limited, Chief Justice Simmons had pointed out that the social dynamics of labor law exemplified the ability of the common law to respond to change in views, values, and conditions of society over time. Justice Rajnath underscored that the common law was neither static nor immutable and must remain responsive to the evolving social values of the Barbadian people and aligned with the constitutional principles of equality, proportionality, and fairness embraced by both the legislature and the people of Barbados. These principles place a high value on and underscore the importance of the dignity of work and the protection of workers' rights. Accordingly, the majority of the court was satisfied that the contextual approach adopted by the majority of the Court of Appeal was correct. Justice Rajnath also considered whether a court ought to take into account the procedural fairness of the dismissal where an employee has been summarily dismissed. The judge observed that the BS&T Employees Handbook issued by the predecessor company, Supercenter, formed part of the contractual framework governing the employment relationship between Mr. Forde and Massy Stores. It was noted that the Employees Handbook, considered consistent with international employment standards, prescribed an incremental approach to the disciplinary action, reserving summary dismissal for only the most serious offenses. The majority of the court was satisfied that disciplinary procedure incorporated into Mr. Forde's contract of employment was not followed. The majority concurred with the findings of the magistrate and the majority of the Court of Appeal that the respondent's actions did not constitute such a serious offense as to warrant summary dismissal. In addition, the majority of the court emphasized that a fair hearing was an integral part of the contractual relationship between the parties. In the circumstances, the majority set out briefly some minimum standards of procedural fairness that ought to be implied into the employee's handbook. And these include 1, the employee's right to be informed of the charge with sufficient details or particulars to enable a proper understanding of the alleged misconduct. 2, the opportunity for the employee to respond to the allegations. And 3, the conduct of a hearing that permits both the employer and the employee to present evidence and to make representations. The degree of formality required in such a hearing will, of course, depend on the particular facts and context of the case. In conclusion, the majority of the court examined some of the factors considered by the Court of Appeal, to wit, the nature and minimal value of the goods taken, Mr. Forde's long, unblemished service, 35 years, without being subject to any negative performance appraisals or written reports or warnings, and Mr. Forde's single act of indiscretion for which he was dismissed. The majority was of the view that even if Mr. Forde had taken other goods on previous occasions, he was essentially dismissed for the removal of condemned goods. Given the contextual approach to summary dismissal adopted in Barbados and the requirement for procedural fairness, the majority was of the view that the actions in question were not sufficiently serious as to warrant Mr. Forde's summary dismissal. The majority was therefore of the view that Mr. Forde had been wrongfully dismissed. Justice Ebo Esuji contributed a separate opinion, underscoring his full concurrence with the lead judgment. He reasoned that the CCJ should not support the erroneous myth that reasonableness and fairness are not proper considerations in cases of wrongful dismissal decided pursuant to the common law. He reasoned that the common law has always been in a state of evolution. It is therefore entirely appropriate that Barbadian common law, as developed by Barbadian appellate judges, should give value to the considerations of reasonableness and fairness through the notion of the humanizing patina in the area of employment law. The dissenting opinion of Justice Barrow found that the magistrate erred in considering the value and nature of the object taken, said to be condemned rice, rather than the violation of the policy against unauthorized taking, the importance of which led the employer to install cameras to suppress it. It was observed that the employee's conduct breached the trust and confidence that was vital to the relationship which was broken between employer and employee. The dissenting judgment found that on the evidence, none of the factors which the Court of Appeal held as giving a humanizing patina to the misconduct existed or operated, and therefore nothing mitigated the seriousness of the employee's dishonesty. In all the circumstances and having regard to the judgments, the appeal was dismissed. The decision of the majority of the Court of Appeal was confirmed. The court concluded that the costs of the appeal were to be paid by the appellant to the respondent. And this counsel is the judgment of the court. I wish to just bring two things to your attention, two very small matters. One, Mr. Koyman, thank you very much for your email response, which we received this morning. You would be happy to hear the court has considered it, and we have made the appropriate change. So when you see the final judgment, you will see the change reflected therein. Thank you for that. And the second matter that I wish to bring to your attention is at the very end of the judgment, the order of the court now reflects the specific sum to be paid by way of costs in this court. Just those two very small matters. Nothing else has changed. Anything further from counsel this afternoon?
Nothing from us, Your Honors.
Thank you.
Grateful to receive your judgment, Your Honours. Thank you.
Thank you, Mr. Khan. And thank you to all. Madam Deputy Registrar, kindly close these proceedings.
Thank you, Madam Justice Raj Nosley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononiwu. Thank you, Mr. Justice Ibusuchi. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.